Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody, and welcome to our December 2023 First Fridays. I hope everybody is in the holiday spirit this morning as we start the first day of December. So welcome, everybody, to Mulcahy Law Firm's December First Friday virtual event. My name is Beth Mulcahy, and I've been a partner in the Mulcahy Law Firm for the past 27 years. Our firm currently represents over 1,000 community associations throughout the state of Arizona. And something that our firm does that's unique, that I'm not aware of any other firm in Arizona that does, is we do a First Fridays, the first Friday of every month, to answer questions at no charge for board members, homeowners, and property managers. I'm sorry, I have a little bit of a cold this morning, so my voice isn't quite as normal, as perky and normal as it is normally. So you'll have to bear with me a little bit today. If there's any trouble hearing us, just send a message in the chat and we'll make sure we talk a little bit louder. So again, welcome to our firm's First Friday virtual event this morning. We also are in conjunction with the Neighborhood Services Virtual HOA Academy. We also are combining today and doing our December class as part of our First Friday class. So welcome to all our viewers. Looks like we have about 55 people with us right now and more joining us on Facebook Live. Just a quick reminder, because we could get a lot of questions, I think we already have over 46 questions this morning, which is awesome. It's limited to one question per association. If you plan on submitting a question live this morning, please be sure to include the name of your HOA or condo and your current role when you submit your question. And then please also be as clear as possible on your questions so that I don't have to ask any follow-up questions, which is really hard to do in a virtual setting. Okay, so very quick update before we get going this morning. On the questions, it's holiday decorations time. I know that we've been busy at our office and at home doing our decorating to get ready for the holidays. And sometimes when we get into the holiday decorating season, it's a good time to remind all of you about the importance of adopting a holiday lights or a decorations policy. Why do we do this? Because sometimes there are complaints because maybe there's noise due to, music being playing outside somebody's home, or the lights are blinking all night and it's disturbing somebody's peace and enjoyment, or they want to go to bed and they can't because the light's blinking on their wall of their bedroom. So we have some suggestions for you. This is, holiday decorations, of course, are a great opportunity to encourage the community to embrace the spirit of the holidays. I know I go all out on decorating at home. I love this time of the year, but we also need to regulate lights and decorations to ensure consistency and that we're not causing any sort of a nuisance in the community. So here's some quick suggestions for your community on a holiday lights and decorations policy. First of all, avoid a total ban on the holiday decorations. Most courts are going to find a total ban unreasonable. Second thing would be to ensure that any holiday-related rules are applied equally to all residents within the community. Survey the community or hold a public meeting if you have a problem to obtain residents' opinions on, what type of decoration should be acceptable or not acceptable. In the past, we've read stories in the newspaper about, maybe a homeowner who goes all out on holiday decorating. And then they're publicizing that people should be driving by to check out their cool lighting display. And it ends up being a traffic jam every single night on, within the community streets because of the large number of people who are coming to look at the decoration. That could be a nuisance in your community. And so for those of you who are just joining us, maybe on Facebook Live, we're talking a little bit about what are some suggestions on holiday lights and decorations. So one of the suggestions is have a meeting, and if there's a problem, and ask homeowners what they think is reasonable. And maybe publicizing to the general public, having a lights display at your home is something that would not be considered reasonable and would create an unreasonable amount of traffic. Set time limits on decorations and holiday lighting. For example, after Thanksgiving to January 8th would be a good time frame to have them up this year. Also, if there's music or if there's blinking lights or something like that, maybe those need to go off by 10 o'clock at night to make sure that it's not disturbing anybody else. And maybe the music should be able to be heard from other homes within the community unless they're okay with it during a certain time period. Another thing that's a good idea would be to avoid the risk of fire. Ask residents to avoid overloading electrical circuits with the holiday lighting and other decorations that you have to plug in. A big trend right now is the move to LED lights. And while they are more expensive than the other type of Christmas lights that we've seen in the past, they use less electricity and they are more reliable. Some other quick suggestions: require that lights be rated for outdoor use with no exposed wiring. Set specific hours, as we already talked about, for the lights and music to be turned off by. Remind residents of the decorating policy in your newsletter or through an email around Thanksgiving time so that people, when they're putting up their decorations, they're aware that there is a policy and that they need to follow it. Another really fun thing to do is to sponsor a holiday decorating contest to build community spirit and or to have a big holiday party to celebrate the season, and then give out awards for who is the best, brightest house or who has the best decorations, who has the best theme, and then announce the winner at the annual meeting or in your newsletter. Create a policy on Christmas parties or other holiday-related events in homes which may be open to the public. You may want to talk a little bit about, if you're having a large party at your home, how we would prefer the parking be handled for that party to ensure that other residents can get back to their homes. Remember, this is a joyous time of the year for many people, but some other people may find it a challenging time of the year for whatever reason. So don't forget to be kind to your neighbors and remember to keep that holiday spirit this year. Okay, we're going to switch right into our questions. I'm just going to do a quick upfront questions count. Looks like we have over 40 questions this morning, which is awesome. Okay, let's just start right out. The first question is, can a management company approve an architectural request without the HOA board of directors or following the CC&R's design guidelines or association rules? What can be done? They've given notice for the end of the month, but they're still handling our records. Apparently, in this association, the management company is approving or disapproving the architectural requests for the association. That's unusual. Sometimes a board will delegate to the management company routine type architectural changes. But in this case, it appears that this management company has been terminated, or maybe they terminated the association, and they were getting to the end of the month. I don't know if they're meaning that this may have been submitted yesterday or maybe it was submitted today. Then the end of the month is December 30th, but they're still doing it. And I think the key thing to do is just the board should just contact the president of the management company or the manager that's handling your property and just let them know how you want this handled going forward. If the board makes a decision on this, ideally the board should be making the decisions on all of the architectural requests that come into your association. Sometimes, like I said, on routine ones, they may, as a board, give the management company authority to approve like an easy one, like a paint change, if you've got like an approved paint palette or something like that. But in this circumstance, it sounds like the management company's leaving and the board wants this power back. So you should just let them know that no more approvals. All the approvals should go to the architectural committee or the board, whatever you see fit. Okay, the next question. Why should I serve as an unpaid director of an HOA and expose myself to civil and criminal fines and prison time for an overlooked matter, unintentional error, or whatever a creative prosecutor can advance? Further, I'm sure that the current D&O premiums will skyrocket for the financial coverage, if any, and of course, likely will not protect against alleged criminal conduct. Okay, well, great question. There are many great reasons why you should serve as an unpaid director of an association. Obviously, to make an impact on your community, to improve things, to get things done. I can't think of all the reasons why I became a board member at my association. Probably at the top of the list was I thought that I could contribute and help to make the association better. And I thought that there were things that really did need to be improved. Some reasons why would be you're helping your community, you're making your community nicer, and you're getting things done. But there is kind of a dark side to being on the board. I'm not going to deny that. In addition to the fact that it probably takes a few years off your life with all the hassles that you deal with, is that sometimes it can expose you to being sued if you're named as a defendant, as a director in the association. I have never in 27 years seen a board member be exposed to criminal fines or prison time for an overlooked matter. So I just want to provide assurances that I have never seen that in the 25 plus years that I've been practicing in this area. Now, obviously, if a board member is stealing money or a board member engages in some activity that's, like a felony or something, that's a different situation. But in my experience, that's not something that board members should be worrying about. Now, how do you protect yourself from civil liability if you get a homeowner who wants to sue the association? A couple things. Number one, you're going to have D&O insurance, directors and officers insurance, and you should have at least $1 million, in my opinion, in coverage. So that's a layer of insulation that your board pays for, your association pays for, and all directors are named as insured under that directors and officers policy. In addition, there's another few layers of insulation. Most of your association's documents and also your association's, the Nonprofit Corporation Act, provide for a insulation in that there is indemnification under the statute. And so under Arizona law, you are entitled to indemnification if you're named as a director in a lawsuit and you are sued. And what that means is that the association is required to provide a legal defense to you. Typically, like I said, that is provided under the association's insurance policy. But if it's not, if there's not enough coverage or something under your insurance policy to cover the claim, the association's board of directors, through the association's funds, will have to defend you in the lawsuit. Again, I've never seen a situation where the indemnification came into play where the board had to make up funds at the association, if there wasn't coverage or whatever. There's been a few times, I will say, that maybe the association was sued for a contractual dispute, like maybe not paying a vendor or something. But usually the directors are not individually named. But if they were and there isn't coverage under the policy, the association would have to pay the legal fees of the owner. I don't think this is something that is a worry, frankly. You have plenty of coverage, insurance coverage, and insulation on this. I wouldn't freak out on this. I serve on my board and I have for 14 years, and I don't have any of these same concerns that you're expressing. Question number 3. We are a cooperative. Okay, and a cooperative is a little bit different than a planned community or a condominium. Can you please tell me about best practices for meetings? Do I understand correctly that we do not have to follow the open meeting law? Okay, so a cooperative is a different legal structure than a condominium or a planned community. And so because you are cooperative, it's set up totally different. You're not subject to any laws that pertain to associations pursuant to the Condominium Act or the Planned Communities Act. What would be best practices? I recommend that you go to our website at mulcahylawfirm.com and you click on our cheat sheet called Board Meetings. Even though you're not subject to the open meeting law because you are cooperative, it still is some great best practices can be gleaned from looking at our cheat sheet on this. So I encourage you to do that. Again, it's mulcahylawfirm.com. And you just click on our cheat sheet section and then type in board meetings. And we have several cheat sheets that I think will help you. Okay, next question. Our planned community has not been enforcing some of our CC&Rs. We would like to follow the steps prescribed in our bylaws and CC&Rs. But if the homeowner refuses to correct the violation, can we then use the HOA dispute process through the Arizona Department of Real Estate and request the ALJ to order compliance? Okay, so great question. So of course, yes, you can, if you are upset about an owner not complying with your association's documents, one remedy that you have is to go to the Arizona Department of Real Estate. And I would encourage you, if any of you are just hearing about this for the first time who are listening in on this call today, just go to Google and Google the words Arizona Department of Real Estate and HOA dispute process or condo dispute process, and it'll give you the link right to the page that explains the entire process. The only reservation that I have on you going to the ADRE on this is that the ADRE will just issue a ruling via a administrative law judge whether or not the owner is in violation of the association's documents. They can't there's not like they'll issue a mandatory permanent injunction compelling them to stop doing it. And so basically, we use the ADRE. There's a $500 fee for whoever files it. And then the prevailing party the other person who loses has to pay that $500 filing fee for one issue if they, should not prevail. We use it because it's fast, it's inexpensive. You don't get your attorney's fees in it unless in your documents you're entitled to recover attorney's fees for administrative proceedings. It's a way to get a judge to say, hey, this person's violating the documents. But there is no injunctive relief that the judge can put the person in jail or force them to do it through the ADRE. So that's important for you to know. If you want to take a more aggressive approach and you want actual judge to issue a ruling that they have to stop doing something or start doing something, then I would go with the remedy of filing a lawsuit in Superior Court and getting a mandatory permanent injunction against the owner, compelling them to do something. And that's a different process. That's going to be through the Superior Courts in Arizona. And so it's going to take a little longer and be more expensive, and you need to have an attorney that will help you with that process. In contrast, the ADRE, you don't need to have an attorney to help you with that process. Okay, next question. On a parking policy enforcement at night, how do we enforce when the manager works in the daytime? Okay, great question. Typically, board members will hire a company to come in at night and do a patrol. There are a number of patrol companies out there that do this. You have to pay a fee to do that. Sometimes you do reporting, like other neighbors do reporting, take photos and then send them to the manager. Sometimes the management company has a patrol that they offer as part of their package. And those are all really good ways for, you to get compliance on your parking policy enforcement at night. Next question. Our current legal team does not seem effective. Are we allowed to hire a different company not associated with our property management team? Great question. Yes, of course. You are the client. You are the ones that make the decisions. And something to think about is some management companies are really pushing their attorney, so to speak. You want your own independent attorney who is going to be working for you as the association. You don't want the attorney that is potentially going to take the management company's side if there's ever a disagreement between you and the management company, the board and the management company. I mean, of course, all management companies probably have some sort of a preferred list or whatever they call it. Some of them actually actively push just one law firm. I think what you certainly are well within your rights if you're not happy to say, hey, we want to bid this out and we want to meet some other law firms, and they should be providing no resistance to that whatsoever. Sometimes we'll see unprofessional behavior by a management company in that if they can't have the attorney that they want, then they start trashing other attorneys in the industry. And that is just completely inappropriate. The board makes the decision who they hire. And sometimes the rationale for not wanting to work with the law firm might be because the attorney has said to the management company in the past before, you're wrong, and I won't agree with you on this. I'm going with my client. I know I've seen that happen numerous times throughout my career. So the board makes a decision on all vendors, including your legal counsel. And secondarily, think twice when people say something that's unkind about somebody else, that there may be some motives behind that. And do your own investigation to determine what's going to be the best fit for your association. And as part of your own investigation, check the references of whatever lawyer that you want to hire to make sure that they are doing a good job for the clients. Okay, next question, number 7. If your CC&R states a way of holding an election via a description, can the board make changes to that if it provides an easier, less expensive way to accomplish the same task? So I kind of feel like this might be a smokescreen question for if we only have a few people running and there's only 2 spots open and 2 people that are running for the position of being on the board. Do we still have to follow corporate formalities and actually have an election? Yes, you do. So another example would be, what if our CC&Rs or our bylaws state that we have to have an election committee that solicits candidates, et cetera? Do we have to follow that? Yes, you do. If you don't want to follow it, the best thing to do would be just to amend your documents to get rid of it. Okay, next question, number 8. I understand that if an HOA allows a violation that is clearly observable to go without intervention for a considerable time, the CC&Rs may become unenforceable due to the association allowing it and taking no action. Is this true? So short answer on this would be yes. Under the doctrine of waiver and latches, if the association is aware of a violation and doesn't take action to enforce the correction of it, the association may have waived their rights to enforce it. Now, of course, under Arizona law, there's a 6-year statute of limitations we have 6 years to file a lawsuit for breach of contract. An owner can raise a defense of waiver and latches. And if the violation has existed for, let's say, more than 3 years, and the association hasn't done anything to enforce it, the association may have lost its right to enforce it. If your association is in this situation and you want some advice, reach out to our law firm. It really is kind of a factual situation where it's a case-by-case situation. We want to look at all the facts on the matter and give you good advice as to whether, in fact, the violation is unenforceable because of the delay in the association pursuing the violation legally. Okay, next question, number 9. What are the ramifications and repercussions of not completing the audit required by Arizona Revised Statute 33-1810 for 4 consecutive years for a HOA? Just briefly, under Arizona law, ARS 33-1810, also condominiums have the exact same section in the Condominium Act, so you're subject to this too. What you need to know is that every year an association needs to complete an audit, review, or a compilation of its financial records. So we're getting close to closing out the 2023 year. So how the law works is this just needs to be done within 6 months of the year-end date for the association. By June 30th, June 30th, 2024, each association would need to complete the audit, review, or compilation of its records. Remember, under Arizona law, unless the planned community documents or the condominium documents require that the audit be done by a CPA, usually it's in the bylaws, anyone can do this audit, review, or compilation. I don't know for your particular association, I don't know, maybe the treasurer did it, or maybe they had a committee do it, or maybe the board as a whole did it. Do they have something in their financial records showing, like a piece of paper saying, we conducted the audit, or we conducted the review or the compilation? We did a compilation of the financial records of the association. Obviously, ideally, we want this audit to be done by a CPA because that's going to be the most independent person and it's going to be the most thorough, comprehensive, trained review. But not every client, not every association has the money to do that. I think probably what I would recommend for your association is bring this statute to the attention of the board. Ask them to talk about it with their management company or their attorney. Encourage them to go backwards and pick 1 year out of the past 4 years and have a CPA do a full audit of it. Just a random pick of the year. And then going forward, please try to encourage them to be in compliance with this law. And remember, unless your bylaws require the audit to be done by a CPA, it doesn't have to be done by a CPA. Although obviously best practices would be that it should be done by a CPA. Okay, next question. Our board is operating illegal executive meetings and not following procedures. How can we get a legal advocate for concerned residents? A couple ways. You can hire an attorney that would represent the concerned residents and write a letter to the board. You can pool expenses that way by having everybody contribute a certain amount of money, and the attorney represents all of you and can send a letter to the board. You could send a letter to the association's current board with a copy to the association's attorney outlining your concerns. And I can assure you, if I'm the attorney for that association, I will ask to have a meeting with the board and go over how they're handling executive sessions. You can go to the Arizona Department of Real Estate and file a complaint meaning that you can ask for a hearing and have an administrative law judge take a look at this. You can file a lawsuit and have a Superior Court judge look at this. You can run for the board yourself, try to make change from the inside. All of these are different options that you have if your board is conducting illegal executive meetings. But first, I would start out by providing them with a copy of the statute and also CCing the attorney for the association so they're aware of this concern. Because remember, the association's attorney represents the association, and we don't represent the individual board members. And we need to do what's in the best interest of the association when we're giving legal advice. Okay, next question. Regarding the revised House Bill 2251 for condo insurance. We are condos with a horizontal regime. That's kind of code word for where our condo has been around for a long time, at least since before 1986. And each homeowner has its own full inside content and outside structure insurance as it is required by our CC&Rs. Does this new law have any effect on our community? We are duplexes, not a single building. Okay, so I don't think so necessarily. I mean, the new law is going to have some impact on your association, but I mean, basically you need to look first at what do your documents say in terms of what sort of insurance coverage your association has to have. Secondly, really the change that, I can see that comes to mind right away is that whenever there's a loss on the association's insurance policy, because I'm sure you're carrying insurance for the common areas of your association as well, whenever there's a loss that's made or a claim that's being made, if the association, doesn't want to make the claim directly to the insurance company, the owner would be able to do that under these circumstances, under the new law. So that's one thing that you may want to look at. You may also want to have an opinion from your attorney as to, hey, do we want to keep this coverage the way it is under the documents? It's kind of unusual for a condo to have the owners insuring the exterior of the buildings, and maybe get some advice on how this is working and whether it's something that you may want to change in the future. Okay, next question. Question number 12. My understanding for calling an executive session is that it is included on the agenda, and one of the 5 allowable reasons to go into executive session is listed. It is now being said that there is an exception to this requirement, and all that needs to be cited is Arizona Statutes 33-1248, parts 3 and 4. Is this correct? You know what? Technically, I guess it is correct, because if you're going into executive session, you're just supposed to notify the owners in advance what sections under, Arizona law, and there's a section in the Planned Communities Act and a section in the Condo Act that talks about the reasons that you can go into executive session. So it appears that your board is just giving the statute number and saying this is why we're going into executive session. I mean, I guess technically they are complying with the law, but I think it would be a good idea for them to state exactly what those sections state so that members have a better understanding of, what the board's going to be discussing in executive session. So just copy the law and then cut and paste it right in there so that the owners can see exactly what you're going to be talking about. I think that is best practices in my opinion, but technically they probably are complying with the law. Okay, next question. Our bylaws list the principal office of the association to be the address of the former board chair, who is no longer an owner nor living at that address. How do we update the bylaws to reflect either the current board chair, or can we make reference to the current board chair residence without stating a physical address if this changes from year to year? It's kind of uncustomary that your bylaws would have this much detail, frankly, in terms of listing who the former board chair's address is, et cetera, and their phone number, their contact information. So what you may want to do, yes, I think you can amend this out, of course. Just look at the amendment provision in your bylaws as to what the procedure is and then follow it. What you may want to do is have this be changed to the statutory agent for the association, which is the agent that's listed as the contact person through the Corporation Commission for your association, because that language is never going to change. The statutory agent will always be used as the contact person, and it's updated annually through the Corporation Commission. And you wouldn't have to update it annually, and it'd be a uniform place that people could go look to find out who the contact person is for the association. And then internally in your association, if you have a newsletter or something, then you could put, here's how you contact the association if there's a problem, a leak, an emergency. Here are the board member contacts, or here's the management company contacts. You can do that in a more informal manner in your newsletter or put it on your bulletin board, et cetera. Okay. Do board members have to vote for agenda items in open meetings? Ours do not. They vote, in private meetings via email. Okay, so of course, the open meeting law in Arizona, the purpose of it is so that anytime that a quorum of board is meeting to discuss association business, that the meeting is open to your association. And how do owners know about it? The board should be giving notice of the meeting 48 hours in advance of the meeting by conspicuous posting or any other means. So if your board is voting on things by email outside of a meeting and it's not an emergency situation, they are violating the open meeting law. And so what I would recommend is print out our cheat sheet. It can be found at mulcahylawfirm.com. The cheat sheet on board meetings is an excellent summary of information. We also have taught a lot of classes on board meetings and use of email. So go to our website as well on that and look at some videos that we have on this topic, because those will also give a live recorded presentation of what the law is on this. And that should be helpful so that they follow the law going forward. If they don't follow it, then of course you can go to the legal remedies that we've already discussed today, going to the ADRE, filing a complaint there, a lawsuit, hiring an attorney to write them a letter, running for the board yourself, etc. Okay, next question, number 15. We want to encourage residents to pay their monthly assessment via autopay as opposed to checks. Can we apply a service fee to those who pay with checks to get them to switch? My answer on that would be no, because it would be like an add-on fee, and I wouldn't do that. It almost be like a penalty for making them pay by checks. So I would be opposed to doing that, but just continue to encourage people to vote by autopay. And what we found over time is that over time, as the demographics in your association change, you're going to have everybody wanting to pay by autopay. So that shouldn't be, an issue, but I wouldn't penalize them for paying by checks if they want to, because I don't think that would be enforceable if the homeowner that paid by check challenged that extra fee in court. Question number 16, 48 hours notice for meetings as per Arizona open meeting law. Does Sunday count? Yes, it does. So 48 hours is just that. It's not business hours. It's regular hours, including non-business days would be included in the count. So if you notice on Saturday for a Monday meeting, is this 48 hours? Yes, it is. In my opinion, as long as the time matches up, that it's a full 48 hours. Okay, question number 17. If the HOAs of a planned community state all units must be owner occupied, does ARS have a legal definition of owner occupied, or must the CC&R document define owner occupied? Oh, that's a really good question. Look at the CC&Rs first. That would be your first line of defense. Most don't give us a good definition as to what is owner occupied, unfortunately, but check the definition section of your CC&Rs. Maybe you're one of the lucky ones that has that. If it's not in your CC&Rs or your bylaws, then you could look to your city, county, or municipality to see if they have a definition of it. A couple questions that, usually spin off of this is, if we have a section in our documents that says the units or lots have to be owner occupied, does that mean that we can prevent rentals? So I want to address that. It does not, because state law says unless your documents specifically prohibit rentals in your community, they are allowed. There can be restrictions on rentals, obviously, but they have to be written in your documents, like a minimum 30 days, etc. Okay, next question, number 18. How much time do we need to give the community to nominate a potential new board member and vote on a new board member? So what I'm guessing happened here is either it's in between the annual meeting, and your documents require you there's a vacancy on your board, I'm guessing. I would give a request for nominations and give them 2 or 3 weeks to get the names to you. And then I would, vote on it within the next 30 to 60 days. I mean, if the board is voting on it, you just have to notice a board meeting and vote on it. Sometimes you have to get a community vote. And if that's the case, you may need a little bit more time, like the 45 to 60 days. Okay, question number 19. Is the HOA responsible for dealing with excessively barking dogs and aggressive dogs? Yes, you do have some responsibility as a board and an association to look into this and possibly to act. We have a great cheat sheet on barking dogs that I would encourage you to take a look at. So go to our website at Mulcahy Law Firm and click on our cheat sheet tab to look up that particular cheat sheet on barking and aggressive dogs. The more serious one from a safety standpoint is the aggressive dogs. So if the board becomes aware of a dog bite or an aggressive dog in your community, typically you get a complaint from another owner. What I would recommend is that you immediately reach out to your attorney to talk about how serious the situation is. Some things that we will consider doing would be contacting the owner of the aggressive dog and possibly fining them for the behavior, demanding that the dog be placed on a muzzle or have a muzzle placed on it so that it can't bite anybody, making sure that the dog is on a leash at all times, communicating all of these requirements to the owner of the dog. In some cases where the dog is really aggressive, maybe the county comes in, animal services from the county, a complaint's made by the association or whoever the aggressive dog may have attacked, and the county gets involved. And so there are a number of different options when you have an aggressive dog in your community. The first thing you should do is reach out to your attorney. What about barking dogs? This is, really complicated because dogs do bark, but it's the incessant barking all day when the owner's at work that can drive people nuts. So check out our cheat sheet for some topics or some suggestions on different things that you can do. The association sometimes will send a letter to an owner if there is a complaint about a barking dog on their property. It's just hard because we don't have control over that dog. And so the association it's more of a box checker for the association in that we can send letters, and if there's adequate proof, we can fine. But ultimately, we've got to just get a meeting with the owner to get the owner on board to make sure that the dog is set up in a situation where they're not going to be lonely and not going to be barking all day. And sometimes that takes education, and our cheat sheet is a really good resource for everybody for that purpose. Okay, question number 21. We have a leak from a water pipe in a common wall. The HOA states the origin is from a single unit shower. Therefore, the unit owner must pay. The unit owner states the leak is in the water pipe in the shared common wall between the two units, so the HOA should cover the cost. The CC&Rs say the HOA is responsible for repair of plumbing in common areas, and unit owners are responsible for any damage inside the unit. The HOA is saying the actual pipe is single use because it's from a shower in a unit. So does the origin of the leak matter, or where the leak is located in the plumbing line on who is responsible for the repair? These leak questions are always really difficult. So it's hard for me to, comment on this without seeing something in writing from the plumber, number one. And then also something from I would like to see the HOA or condos, CC&Rs as well. But generally speaking, I would be looking to, the origin of the leak is going to be, where is it located, right? I think that's probably the angle that I'm taking on this. And if it's in the wall and the association is responsible for that, that's likely going to be an association issue. But again, I don't have all the facts here, so I can't really individually comment on this one. Okay, next question, number 22. Somebody who's planning to run for the board. Love that you put that in there. Okay, a group of residents are unhappy of how we are spending money and are threatening to picket on the public sidewalk in front of our community. Can we legally stop them from doing this? Ooh, this is like a good bar exam question. Well, it's the public sidewalk in front of your community. It's probably a good question in terms of it's not private property, it's a public sidewalk. And so you may want to check with the city to see what their position is on this, or the county, if you're county property or city property. I think that's probably the best thing you should do. Going back to constitutional law and the bar exam, this is a public place and they probably do have the right to do this. However, I'm sure there's restrictions, so the city will be able to clue you in on that. But the more pressing question here is what's going on that people are so upset that there's picketing? You guys need to have a town hall meeting pronto to talk about what the issues are in your community. Because if people are upset enough to be picketing, and I've never seen this in 27 years. So you've got a very high level of dysfunction right now in your association and you need help. You may also want to have like a boot camp for your board where we can talk about some of these issues. Our firm does boot camps frequently for dysfunctional situations in communities. Something's not right here. Something is not going well. And there needs to be a change in course immediately, because this is very unusual that people are this upset that they're going to start picketing. And we need to talk through the issues, talk with the owners, and try to come to common ground. Okay, next question. Number 23. For a violation of maintenance upkeep, our CC&Rs permit the association to pay the cost for remedying the problem. So it's kind of like self-help, I think is what you're trying to say here, that our association has self-help. The homeowner is then billed for the cost. The board wants to institute a fine policy reserving the cost of reimbursement for extreme cases. Can we establish the fine policy as part of our rules, since fines are not specifically stated in our CC&Rs? So Arizona law does allow you to fine an owner for a violation of the CC&Rs, bylaws, or rules of your association. So you definitely have the right to do this without having it being in your CC&Rs. So I would encourage you to take a look at our cheat sheet on enforcement of governing documents, and also our top 10 cheat sheet, where we talk more about fines and how to levy fines under Arizona law. Okay, next question, number 24. Please comment on the implications of the new Corporate Transparency Act and how it affects associations. Also, will you be doing a training session on this? Great question. We are very aware of the Corporate Transparency Act. We do feel that it does apply to associations as it's written right now. It's federal, so it applies to all associations in the United States. One thing I'm going to say is that it doesn't go into effect until the end of 2024. And we think that the United States legislature is going to clarify this further, so that all of the tedious restrictions of being on a board and the reporting requirements that are required under this law are not going to apply to associations, we think, after there's further analysis by the legislature. I know that Community Associations Institute, which is a national think tank that helps provide information to associations, they are actively working on getting this resolved. So right now, I would say stay tuned. I'm not doing any formal training on this because I think, the purpose of this law was to stop terrorist money from coming into our country and further regulate businesses that might be financing terrorist activities, et cetera. Obviously, our HOA is not part of that. I think that there is going to be a fine tuning on this, and there's no urgent rush on this because it's not even going to apply for another 12 months. So I'm saying stay tuned on it. If it does apply, we will be doing extensive training on it in the fourth quarter of 2024. And no, I do not think it will scare board members from participating on the board. Okay, next question, number 26. What are the consequences if board email votes are not ratified? Is there a time limit from passage to get votes voted by email ratified at an open board meeting? I would say the time limit is you should do it as soon as possible. And remember that if the board's making decisions by email, it really should be for emergency circumstances. It should not be for day-to-day business. Is there a time limit? No, on the ratification, but just try to do it as best and as quickly as possible. Next question, number 27. Is interest earned on reserve funds taxable? I believe that it is something that is, reported on your taxes every year as an association. Remember, you do have to file state and federal taxes as an HOA or condo in the U.S. This is probably a better question for your CPA, but my understanding is that any income that you have, including interest income, is potentially taxable. Next question, number 28. Can an association include a write-in candidate space on the ballot for the annual meeting? I'm told there is no actual law, but law firms are recommending not to provide that option to the members. If no longer allowed, why? Great question. Association board makes the decision as to whether or not a write-in candidate spot should be placed on the ballot or not. And you should also look at your association's documents, because some documents do not allow nominations from the floor or write-in candidates to be used. You're correct. There is no actual law that gives us direction on this in Arizona. In terms of recommending, does our firm, recommend write-in candidate space? I'm pretty flexible on it. In some situations, it's necessary because you only have 2 candidates running and there's 3 open spots on the board. I recommend it in that case because we need 3 people to be on the board and we only have 2 people running. One thing I will say is, let's say you have 5 people running for 3 spots that are open. If you put a write-in candidate blank there on the ballot, just from a practical standpoint, they're not going to get the votes to get elected. So it may not make sense to do it, but I'm not saying don't do it. I'm just saying if you use a write-in candidate and there's enough candidates running or more candidates than there are spots available, it's very unlikely that the write-in candidate is even going to win because people don't know who to write in, right? And so there's no collective effort typically grassroots effort to get a write-in candidate elected. So they're never going to have enough votes to even get elected. Maybe from a practical standpoint, it doesn't even make sense to add it there. But like I said, there's nothing under the law that requires us to not allow it. And I'm neutral on whether I recommend it or not recommend it. I'm neutral on it. It just doesn't matter to me. But lots of times write-in candidates do not get elected because not enough people have the same name to write in. Okay, question number 29. Can an HOA collect fines if a homeowner is in violation of governing documents and fines are reasonable? If not, how are governing documents enforced? Yes, I'd like you to take a deep dive by looking at our cheat sheet on fines, and you can see that in our enforcement of governing documents cheat sheet or our top 10 cheat sheet. But how can you collect fines? So first, you've got to levy them correctly, right? You have to give notice and an opportunity to be heard before you levy the fine. The fine has to be reasonable, as you said. It has to be a violation of the CC&R's bylaws or rules of the association. So how can we collect those fines after you follow the procedure to properly levy a fine? The only way you can collect these fines is by filing a lawsuit in Superior Court or Justice Court. If it's under $10,000, it's going to go to Justice Court. Over $10,000, it's going to go to Superior Court. And basically, you ask the court to give you a judgment, the association a judgment against the owner for the unpaid fines. And that's one way to get people to comply. We've talked throughout this class today about other ways, going to the ADRE, filing a lawsuit. The fines is another option, picking up the telephone and calling the owner and finding out what's going on, communicating. These are all different ways to try to get compliance from an owner, turning it over to your attorney, have the attorney send a demand letter. These are all examples. Okay, next question, number 30. And I'm just going to do a quick check to see how many questions we have. So we have 16 more questions. We received a bill from our landscaper for a storm cleanup, which is about $30,000. The landscaping company's bill shows only the dates that they were here. We've asked them to itemize the bill and provide pictures. We feel that this amount is exorbitant. Do we have any legal recourse? We recently canceled our contract with this company and feel this is very retaliatory. So you canceled the bill and then they sent you a $30,000 bill. Well, I think I would actually ask for some proof. I'd also go back and look at the terms of the contract to see what does it say? What type of reporting requirements do they have for you? How often are they required to do storm cleanup, et cetera? And I think you need to get your attorney dialed in on this right away because this is a lot of money. And they are probably sending you a bill that it's unusual circumstances. I don't like what I'm hearing. So I think further investigation needs to be done. Okay, next question, number 31. When an attorney helps a community update their community documents, such as the bylaws, or add new amendments, can the board of directors keep changing the deadline, the return date, over and over again until they fulfill the amount of consent or vote needed? For example, extending it a few times, like 4 times over a 1.5 year time frame. I would say that this is a pretty common thing that happens in our industry. Now, if the vote, let's say that you have to have your documents require a vote of the members at a meeting to amend your CC&Rs, in that case, extending it beyond that time is problematic unless you just continue to extend that meeting and you don't adjourn it. You just extend it to a different date. I'd be lying if I didn't say this worries me when associations do this a little bit. If it's just a matter of, we just need your written consent and there's not like a formal meeting that's required, it's, less of a worry because basically we're just saying, please try to get your signature back by X date. And if you don't have it by the X date, you can extend it. One thing that you may want to do is put on the ballot that, hey, this date is going to get extended if we don't have the requisite votes. So that would be one protection that I would really recommend if your association is doing this, that the original ballot should say, please return it by April 1st. Please note that we have the right to extend the return of ballot date going forward. Okay, next question. Number 32, in a condo complex, I believe it was mentioned on a previous call that for sale signs could only be placed on the property itself. Example, in the window of the condo being sold or on the patio or balcony. Does this mean that the HOA can tell realtors that for sale signs are not allowed in the common areas at the entrance to the community or at the entrance to the community? So yes, that is correct. The association doesn't have to allow that. Many do, but they do not have to allow it. And the law doesn't give owners the right to put a for sale sign on common area property the way that the law is currently written. However, like I said, the board can allow it if they so choose, and they can make the owner use a certain type of sign if they want uniformity, etc. Okay, question number 33. If less than are required for a 2024 HOA board run for election, does the previous board continue until the president can appoint a new board member? Let's break this down a little bit. If you have less than required for a board for 2024 board run for election, does the previous board continue until the president can appoint new board members? Okay, so I'm not quite sure. I'm not understanding this question, so I'm sorry. I'll do my best to untangle it. Let's say that you have not enough people run for the board, is what I'm understanding here. And I guess somebody's term is up, the seat is up, and I'm trying to piece this together here. So you've got an election, there's not enough people running for the vacancies. You've got previous board members that their seat is vacant and they're not running. And so do they continue on until the president can appoint new board members? This question, this is like a really good example of, I don't have enough information to answer this question, but okay, I think this is what's happening. So I think, like I said, there's vacancies on the board. The previous board doesn't want to run. So yes, the previous board would continue after the annual meeting if we don't get candidates to run for the board. Now, if the previous board resigns and the president is the only person left, which I think is what's going on here, you have to look at your documents, because typically, the remaining director can appoint people to fill the vacancies. But this question isn't worded well. It's really hard for me to understand exactly what's going on. So I'm doing the best to piece it together, but I think that's what the question is, and that would be my answer. Okay, question number 34. Board members don't like getting 3 bids and don't care if the vendor bids include details of materials and description of the work. Example, like the contract has 6 windows and 9,500, no other descriptions. Is this a fiduciary duty for the board to get bids? And do they have to be detailed? This is kind of a tough question because over the past few years since COVID, I would say that it's been more difficult to get 3 bids on certain projects, especially small projects. And so I would say best practices would be to get 2 or 3 bids whenever you are hiring a contractor. If it's a contractor that you've used many times before and it's a small project, only using that contractor, I'm fine with that. Try to get the bids to be more detailed though, because if there's a problem, the more detail you have on there, the better it is to help defend if there's a problem or help prosecute against somebody if there is a problem. Okay, number 35. How long is the retention period for HOA financial records, such as bank statements, tax records, handwritten ledgers, etc.? For these different things, I would suggest 6 years for sure. I would really encourage you to take a look at our cheat sheet on this topic. It's called Records for Associations, Records Retention, I think is what we call it. We also have some videos on our website on this same topic. And so basically, the retention period for HOA financials is six years. And I encourage you to look at our cheat sheet on how long you should keep the records, because for some things, it could be shorter, some things longer. Like meeting minutes should be more than, you should keep them forever, frankly. Executive session meeting minutes and regular meeting minutes, you should keep those forever. But bank statements and tax records and handwritten ledgers, you can keep those for 6 years because that's the statute of limitations that you can be sued. If you have the capability to put records digitally, I prefer that, frankly, and just digitalize everything. And then you can keep everything forever because it's in a digital format. But check out our cheat sheet on this. We also have some great videos on the same topic on our website at mulcahylawfirm.com. Okay, next question. We have a property that has been owned by an individual, not an LLC, for many years, but was used as a rental property. Recently, we learned that this homeowner has passed away, and each of the 3 properties that she owned here in our community has been converted into LLCs by her family members. It appears they are still being used as a rental property. One of the rental properties has suddenly started a tattoo business at one of the properties with a commercial sign for said business hanging in the window. Wow. Sometimes I think I've heard it all, and then I get a question like this. Our community is zoned only for residential, and our CC&Rs do not allow any commercial business that brings traffic into our community. What legal steps can we take as an association to effectively close or have this tattoo business shuttered? Okay, you need to get your attorney, and I think I'm the attorney for your association, dialed in on this right away. We need to send a letter to the LLC and also to the owner, telling them to cease and desist immediately. Also, I would contact the city, town, or municipality that this particular association is located in. They also would, their code enforcement department also would very likely shut this down very quickly. Okay, next question. Number 37. Many homeowners confuse their HOA membership with ownership of the HOA, and as such, they assume all HOA employees and members of the board work for them, rather than on behalf of the community as a whole. In light of this, how would you respond to homeowners who believe their membership translates to ownership of the HOA? That's a tough question. I agree that it's kind of a fine line, right? Because board members are elected by the homeowners, right? So kind of like they're our constituents, right? But as board members, sometimes we have to do what is best for the community. And maybe the owners don't like it. Like, I have lots of examples of this where the association is in financial trouble and we have to levy a special assessment or we have to increase this assessment rate, and owners don't want that. But as board members, we have a fiduciary duty to act in the best interests of the association. So what I would say is, how do we respond to homeowners who are saying to us, hey, you work for me and you need to be doing what I'm telling you to do, which is, it's hard, right? It's a really hard situation. So I think what we do as a board is we take a deep breath, we listen. It's really important to listen as a board member. And we listen to their concerns and we acknowledge whatever they are upset about or frustrated about. And we let them know that we are listening, and our job is to listen and then think about what's best for the association after consulting with our trusted advisors. And while we may not always, as a board, do everything that they want us to do as homeowners, we are doing what we feel is in the best interest of the association. And we are doing our fiduciary responsibility by acting in that manner. And it's a hard thing to do because you can't keep everybody happy. But I think that's a good answer as you are listening to what they're saying. Okay, next question. Question number 38. For the first time, our association has hired a full service management company. And when they got landscaper bids for us, the lowest cost proposal they gave us was from the son of the company's owner. That sounds fishy to me. Do you see an issue with this in terms of conflict of interest or anything else in the future? Yes, I do see something, that's probably not a good trend here. Okay, so you got a full service management company to help you with your association's, landscaping. Did the bid for the landscaping, did they go to the management company? Did the management company open them and see them? That's a question that I would have. I think if they did, I think possibly something that we might be able to think about is, hey, did they look at the 2 other bids and then come in with the third bid as the lowest bid? which obviously is problematic. Also, do you want to hire a management company, the son of the management company owner? What if you have a disagreement with either of them? Is that going to be a good situation? Are you going to lose both the landscaper and the management company if that happens, if there's ever any sort of disagreement? So, my feeling would be I wouldn't be as inclined to go with that bid based upon what you're telling me. That's just the bottom line. If you asked for my opinion, I was your attorney, I would say, hey, that seems a little fishy to me. Second, I think that there could be a conflict of interest here. And if you do decide to go with them, there should be full disclosure in a board meeting that this was disclosed, that we've talked about if there's ever a problem, how that will be handled, and have that reflected in the minutes. I'm not saying you can't do it. I'm just saying this whole situation seems a little bit fishy. Question number 39. Our annual meeting is in a week, and our 2024 budget is on the ballot. Our very outdated bylaws require a quorum of 34 votes. We are a 55 plus community, and our homeowners are not very interested in or involved. So it's always a struggle to get to 34. What happens if we don't? Are we not allowed to operate under the proposed budget? So one question I would have for you is, looks like you're a planned community based upon the information that you put in the name of your association. I'm guessing that you are because it's saying HOA. One thing that I'm going to ask you is, do your documents require to have quorum to approve the budget? And have you talked to an attorney about this? Because you may not need to have your budget approved by the owners. Typically, in a planned community, the board just approves the budget unless the documents require. And in your case, you're saying you have outdated documents that may require it. So one thing you might want to do is, if it's in your bylaws, get rid of that section, amend that section so you don't have to get that vote. Another thing is, if it's not in your documents at all that you have to get a membership vote to do this, the board should just approve it. Otherwise, you're going to have to, continue forward and try to get those votes because it's part of the bylaws. It says that you have to do it. You may need to renotice the meeting. You may need to go door to door to get ballots, etc. Okay, 7 more questions. And that's good because my voice is running out. So hopefully we make it for 7 more questions. Question number 40. An owner remodeled 2 bathrooms after we denied her architectural change request for multiple reasons. She also did not get permits. Since the remodel, the downstairs unit has had multiple water issues and leaks from the ceiling. The owner of the upstairs unit will not take responsibility and keeps telling the HOA to file an insurance claim. Okay, a couple things. This is definitely a problem. I think you need to get your attorney involved right away on this. What I would do if I were looking at this is I would look at the architectural change request. It's unclear from the question, but did you deny some of the changes that this person was doing? And did they go ahead and do them anyways? Do you have the authority to enter the unit after notice and look at the bathrooms to see where the root cause of the problem is coming from? Yes, this might be the type of thing that you make an insurance claim on, but you need to act in a very prompt manner. So I would say reach out to your attorney today, start investigating this, have the plumber look at where the leak's coming from, and then after you have all the facts, try to make the best decision with the attorney's input as to how to proceed. Question number 41, our CC&Rs restrict on-street parking, and our CC&Rs were recorded in January 2019. The new parking bill states it only applies to HOAs which were recorded prior to January 2015. Does that mean that after June 2025, our CC&Rs are not enforceable? So I have to go back and look at the law on this. I know this question always comes up with the states. Let me just scroll back up to the top. I'm hoping that we have the updated version of this on here. Let's see. I may have to push this one till the end. And I have Callista helping me online today. Callista, on the last script that we did for the last neighborhood services class in November, towards the end of it, we had the statute on this. And so can you pull that for me and put it on the script and then I can look at it? Otherwise, if we can't get that quickly done, I'll email this person their answer today. Okay, so let's move on to the next question and then I'll come back to this again. This is going to be for Callista. It's the question on the parking bill that we put at the end of the script last time. Okay, question number 42. How to prevent felons on board and proliferation of drug odors by residents? Okay, the best way to prohibit a felon from serving on the board would be to write it into your documents. Basically, have it in your bylaws that you can't be convicted felons, can't run for the board or be elected to the board. How do we stop, drug smells by residents? I'm assuming that you're talking about marijuana. Basically, that's probably already in there as a nuisance. You might be able to enforce it that way. Or you need to also look at, are they smoking on common areas? Are they smoking in their unit? Are there any sort of filtering things that they can do that will help us so that the smoke smell doesn't travel from unit to unit? I'm happy to consult with you on this. I've done a lot of cases on this, unfortunately, over the past few years. So just know that that is something that can be managed. You might want to get your attorney involved to help you. Question number 43. Can we restrict real estate salespeople from canvassing our neighborhood? We are not a gated community and do not own the streets. That's a unique question. I mean, I haven't seen that come up. It's from one of my favorite clients. So I'm sorry that that's happening to you. I mean, I guess what you could do is put up no trespassing signs and state something along the lines on a sign at the entrance of your community that solicitations are not allowed. If you know who they are, you could write them a letter and just say, you are not allowed to, go door to door within our community pursuant to our, rules that you may have implemented, say this. So I think there's a way you can do it. You may want to reach out to our firm to help you with that. Question number 44. When having an election for the HOA, can the board restrict signs on community property? So quick answer to that would be no. What I would like you to do is look at our cheat sheet on the new legislation. It'll give you more information on that. So it would be the cheat sheet from 2022 and 2023. But ultimately, if an owner wants to put out a sign on their property regarding, the board election, they can do that from the date that the ballot is submitted to the owners all the way to 3 days after the election. It can be a handwritten sign, and that's it. Okay, question number 45. Regarding the vote to continue regulating our roads, our board decided to hold a Zoom homeowner meeting to discuss and do a roll call vote on this. If passed, how do we submit the vote to the county? Okay, so this is a good time to answer this question because we've got the previous question that I was going to go back to, and then this question. Okay, so let's break down this law. It's Arizona Revised Statutes 33-1818. And this is the new House Bill 2298. And it talks about authority over public roadways. So in order for this law to apply to your association, a few things that you need to hear. First, you have to be a planned community, right? Second, the roads have to be dedicated to the membership, okay? Let's talk about it if it's recorded after, if your CC&Rs were recorded after December 31st, 2014. So that's for the question for the person that said our CC&Rs were recorded in January 2019. So this answer applies to you. Under 33-1818, if you are a planned community and if your roads are dedicated to the public or to the city or town that you live in or to the county, and your CC&Rs are recorded after December 31st, 2014, which yours are, an association has no authority over and shall not regulate any roadway for which the ownership has been dedicated to or is otherwise held by a governmental agency. If your CC&Rs were recorded at that time, January 2019, that means that you have no authority over those roadways. Okay. So let's look at the other question from the other person. So the other question said that you had a Zoom board meeting or homeowner meeting to discuss and do a roll call vote on this. So I don't know when your CC&Rs were recorded. I also don't know if you are a planned community. I also don't know if your roads are dedicated to the public, right? I also don't know when the vote was taking place because, this new law went into effect October 30th, 2023. So there are lots of variables here that I don't know. I'll do my best to try to answer the question. Short answer would be, I'm not sure a roll call vote, would work in this situation, honestly, because if it's challenged, the minutes would have to reflect each person's vote. And, what about the mail-in ballots? Did they vote on that as well? We can't count those unless they voted on it. A lot of unknown variables on that question, so I don't think I can answer it. I would encourage you to take a look at Arizona Revised Statute 33-1818 because that does have more information on that statute. Okay, next question. I think this may be one of our last questions. It is. Okay, so our last question for today. Are there state laws governing the process for voting on a special assessment? And then the follow-up question on that is related to the use of mail-in ballots, proxies, deadlines for ballot submission, postmark versus actual receipt. Our CC&Rs are still dated, meaning proxies are allowed. Okay, so great question. So there are some state laws, but we want to, just to kind of give you a general overview, you first want to look at what your documents say on a special assessment. The procedure that's outlined in your CC&Rs is going to be what you need to follow, okay? There is no special law on special assessments specifically, okay? So you got to look at your documents. There are laws that relate to absentee ballots. And I think on our cheat sheet, our top 10 cheat sheet, we give you that summary of what are the requirements for a mail-in ballot. Proxies are no longer used under Arizona law unless you're under developer control, which I know your association, you're well past that, so you can't use proxies anymore. Even though your documents may talk about proxies, you know that's outdated and conflicts with state law. You need to go with what the law says on absentee ballots. What about ballot submissions? Unless your CC&Rs give a specific requirement, there really is no requirement in terms of, like, let's say you say all ballots have to be back by X date. As long as it's reasonable, that's fine. We have to give them at least 7 days to vote on it, though, under the law. So since special assessment is a really important vote, obviously you need money to do something big in your community, a large capital improvement typically. You may want to run whatever you're planning to do by your attorney to make sure that you're completely following the law on this particular matter. Okay, let's switch gears and kind of talk a little bit about where we're going for the rest of the year, right? We've finished the year, and this is our last seminar for 2023. So I want to thank everybody for participating and being a part of our First Fridays that we've had all year. It's been a pleasure to work with all of you and answer your questions. We've answered thousands of questions this year through our different presentations that we've had through neighborhood services departments and through our First Fridays. I'd like to thank very much our partnership with the different neighborhood services departments throughout the Valley that partner with us. It's been a pleasure to work with you again this year, and we're including this class as our neighborhood services class for December because of the holiday. So I'd like to give a shout out to them and let everybody know that we are going to be conducting more virtual classes through our neighborhood services departments throughout 2024. So we look forward to our next class for that, which is going to be Tuesday, January 16th. And as part of that class, we're going to be talking about this particular topic. We're going to be just doing like a hot topics type thing where we're going to be discussing all of the different hot topics that are really important in our industry right now. So we encourage you to tune in for that. And also our next First Fridays is going to be Friday, January 5th. So we encourage you to tune in for that as well. One last thing, we encourage you to leave a Google review for our firm. We're going to be sharing a link with you on that. It's a great way for us to get feedback as to what type of classes you want to see. How are we doing on our classes? Do you like this format of having the First Fridays? And is there anything that we can do to improve the classes to make them more interesting and beneficial for you? So if you wouldn't mind sharing a Google review with our firm today, we would sincerely appreciate it. Last but not least, happy holidays to everybody. We hope that you have a very safe and happy holiday season with your families. And we can't wait to get back at it in 2024 and start teaching our neighborhood services classes again the third Tuesday, of every month, and then getting back on our First Fridays, which the first one will be the first Friday in January. So happy holidays, everybody. Take care and look forward to seeing you again in 2024. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.